Welcome back. My name is Patrick Nolan. I'm an attorney licensed in the state of Missouri. This is Pat Talks Law, Windshield Time. Today we are going to talk about a growing problem in the states that have legalized marijuana and have approved medical marijuana. This is an issue that is impacting people in those states pretty severely, and that is problems with the federal bankruptcy code. In Colorado, rather recently, the federal bankruptcy court told people that were seeking a bankruptcy under Chapter 13. That's where they have to have a repayment plan approved over 3 or 5 years. And the trustee manages their money for them and says what they can and can't spend money on. It's a pretty invasive, frankly, it sucks. It's like having an allowance in high school again. So the bankruptcy court, in its infinite wisdom, said that it will not approve them having medical marijuana. Marijuana, of course, is illegal at the federal level. And since it is illegal federally, they are not approving it. Inri Andrick, the debtors were a husband and wife who filed bankruptcy petitions under Chapter 13. Their disposable income calculations, debtors disclosed they spent $900 a month on medical marijuana. Claiming special circumstance deduction for medical marijuana, the debtors' plan provided for distribution to creditors about 38%. Now, if you have the money and you're in a Chapter 13 bankruptcy, you got to pay the people you owe. If the deduction for medical marijuana was backed out, they would have close to 100% distribution and repayment of creditors over the time of the Chapter 13. So that is a significant issue. Please stay in your lane. You can understand, one, the expense. However, it's a medical related expense. The court would likely have approved it if they were spending that money on OxyContin. So that's an issue. And that's a growing issue for people who are filing bankruptcy as we have more and more states with medical marijuana. Now, this isn't really a surprising decision if you've been following the bankruptcy courts and the marijuana rulings that they've given. Companies have not been able to file Chapter 11 bankruptcy. So, because marijuana-related industry is illegal federally, even non-plant touching marijuana-related industry has been precluded from being able to seek bankruptcy protection. That is a significant problem. There's been enforcement action that has increased. That is something that is not going to be a good thing. And, law professors and tax experts have roundly agreed that right now, the way the law is, bankruptcy protection for businesses that are involved in the cannabis industry is largely non-existent. And while that's unpleasant, it's not really a surprise. And until we get action at the federal level to legalize marijuana or even legalize medical marijuana, there's going to be a problem. And really, since 2012, we've had 10 states and the District of Columbia have legalized marijuana for recreational use. An additional 23 states have legalized medical marijuana, including Missouri. Now, at the federal level, the Agriculture Improvement Act of 2018 decriminalized hemp and hemp-driven cannabis, and I totally mispronounced things like that, sorry, cannabidol, and it removed them from the definition of marijuana, which is a plus. I mean, that's good. But we haven't solved the problem yet. We're making small steps. So some of these businesses are going to do very well. However, with the federal law, there's a lot of companies that simply aren't going to touch it. You've got your banks that a lot of them are refusing to handle marijuana or medical marijuana accounts. The ones that are handling them are charging exorbitant fees, $10,000 a month to have an account with them. I mean, that's ridiculous. Excuse me. Wow. Okay. Now, in Colorado, In Re Way to Grow Inc., bankruptcy court, again in Colorado, and in Colorado you have recreational marijuana use that has been legal. But the bankruptcy court dismissed their bankruptcy filing by 3 different companies that sold equipment to indoor hydroponic gardening. They sold that equipment to growers of a variety of crops, not just marijuana, and their business plan and future expansion relied upon continuing sales to marijuana growers. The bankruptcy court pointed out that a party may not seek bankruptcy relief while violating or continuing to violate federal law. So, despite the Colorado law that approved, authorized, and legalized their actions, marijuana is still a Schedule I drug under the CSA, and growing and dispensing marijuana is a federal crime. Therefore, businesses that grow or sell marijuana, supply equipment to marijuana growers, they can't take advantage of bankruptcy to liquidate, even shut down, because they're violating federal law by growing and selling their products. If they're liquidated, then the trustee or the debtor in possession would be forced to violate federal law by selling off their equipment when it sold off the marijuana products. And they can't do that. So, according to the Way to Grow court, and this is a decision that's going to impact a lot of other entities, the prohibition on bankruptcy relief also extends to businesses that do not touch the plan. In other words, it's no defense for a business to argue that it is not a grower or a dispenser, and that its products, like the hydroponic gardening equipment, are not then property of a business that touches the plan, because they can be sold to non-marijuana customers. Okay, if the equipment the company sells can be used to grow marijuana and is in fact used by marijuana growers, that company could be denied bankruptcy relief in the future. Okay. Now, hemp and hemp-based products may be a slightly different thing. However, you've got different regulations. So, the question on hemp is really up in the air, although I think that hemp producers and hemp producer vendors will be able to seek bankruptcy protection. However, CBD is not an FDA-approved drug. It's not an FDA-approved dietary supplement. It's not approved at all. There will be warning letters coming for that. And frankly, there's a possibility that a person may be denied bankruptcy protection under those circumstances too. So right now, bankruptcy protections for the businesses that are starting up, that's going to be tough, because if a entity cannot seek bankruptcy, investors cannot be made whole. And, that's going to be a problem for a lot of people. In Re Way to Grow went out of business. They can't clear up their accounts, pay off their creditors. At some point, they're just going to go under, and the creditors are going to have no recourse. If that was a sole proprietorship or partnership, and even LLCs and poorly managed corporations, where the owners are not taking action to secure the corporate veil and protect themselves from creditor claims. Individuals are going to be responsible for corporate debts for life until they're paid off. Some of these debts are going to be massive. I mean, the cost of starting up a grow facility, you're buying a lot of equipment. If that grow facility goes under, then the equipment provider may not get paid. If the equipment provider doesn't get paid, you've got a problem. They go under. But because they're providing equipment to marijuana growers, they're not going to be able to use bankruptcy court for protection. If that debt, because of the structure and because of failures to maintain the structure properly by the owners, allows that to be attached to the owner individually, you could have a person with a $3 million debt for life that they can't bankrupt off. Congress is going to have to find some relief there for people. We're going to have an entire new class of underclass of debtors that can't get rid of that debt. And that is not the intent of our bankruptcy laws or our Constitution. So this is one of the growing areas that we have to pay attention to, especially as we have so many businesses getting ready to come online in Missouri. Some of those businesses are going to go under. Hopefully, they will have set up a proper corporate structure and protect the investors. If they have not, if it is a sole proprietorship and they go under, they could well find themselves stuck and be unable to seek bankruptcy protection. This is your medical marijuana update for today. Please go ahead, hit like, subscribe, hit the alert button. We are going to be continuing to put out our weekly series on, layperson's law school, along with the various Windshield Time and other updates we do at random times during the week. Thank you for watching. Again, hit like, subscribe. We'll talk to you later.